better. Just a moment before I do that, let me deviate just for a moment. And let me do it because I am pained. I'm hurt. And this has not been directed at me, but a sister congresswoman. And when I say sister congresswoman, I am looking at the landscape of women, because it has not been easy for women, Madam Speaker, to get to the United States Congress. We've not been here long in large numbers. We've been one or two. We can go back to the 1800s and beyond to know that women did come into the United States Congress, but very few. And certainly women of color, very few. And then might I add something else, the wonderfulness of the multiculturalism of faith, the different faiths that are in this place. It is finally a recognition of America as the unusual experiment, different languages, different cultures, under one flag that you sit directly in front of, the United States of America. And then, as I stand here, right above your head, it says, "In God we trust." So whatever way you craft your faith, our Constitution says that you are recognized and welcome under the First Amendment, freedom of religion and freedom of access. That is one of the reasons that, although imperfect, America has been able to go into faraway places and find connection, because they have citizens who are connected to those places. Then why would we have the trash of discourse? Why would we disgrace our positions, the oath we take, by suggesting that a person of a different faith that wears her own faith in her job is a terrorist? Madam Speaker, there were times when I first began to wear braids that I was looked at askance. I frankly believe there are opportunities that I did not get because I wore braids, but it does not in any way even equal to being called a terrorist or black heart, to be made light of, to have the faith made light of, to not understand that the words in this hallowed ground, this most powerful lawmaking body in the world, is heard around the world. As we speak today, someone is wondering what Americans are saying. The easy way to do it is to tune in, as we may not think, to the floor of the House or the aftermath. The words of a member of Congress or a member of the United States Senate or the president carry great weight, make a lot of noise, are listened to. And the billions of Muslims around the world should not be denigrated for tomfoolery. But what about, as I've been told, our own member, Ilhan Omar, receiving death threats because of someone's ugly words? It is time for the federal government to step in. Lives can be lost. Oh, we used to have that old phrase, "Sticks and stones can break my bones, but words will never hurt me." And that is the context of yesteryear, when the words were, in essence, light. But when you begin to play with the minds of those who came on January 6th, we just heard testimony that said, "I came because the former president called me to come." Then who is safe when we say words? This is not chatter. It is vile. And it can hurt people. Can it hurt the innocent Muslim woman on the street in America? Or Muslim man, or Muslim family, or Muslim child going to school? because it has a megaphone? Can it endanger our colleagues, no matter who they are? It is appropriate for the action of this House or the time for the federal government to step in. I offer my concern, love, and affection for my colleagues and my sister congresswomen. But I cannot, and we should not, tolerate dastardly language and non-humorous insults and threats to people's lives. How dare you? As I said, I want to talk about the idea of when the federal government should come into action. And Madam Speaker, let me ask you, how much time do I have remaining?
The gentlelady has 20 minutes remaining.
Thank you so very much. The federal government is an umbrella on a rainy day. So the context of my remarks today will be about criminal justice issues and the unequal results that has come about through state laws. Let me say that the juries have spoken in two important cases. As a trained lawyer, I'll say it again, the jury has spoken. But it does not mean that I have to accept, in one instance, the ultimate decision based upon the context of that trial and all of the trappings, the judge, the prosecutors, the defense, and the law. So let me begin very briefly. What is self-defense? It is a legal justification for the otherwise illegal use of force. You have killed someone in most instances. In the instance of self-defense that results in a death, although an unlawful killing did occur, it is considered a justified killing. Do you know how many lives are lost, particularly people of color, by being defined as a justified killing? To succeed on self-defense grounds, an unprovoked attack, the killer was not the aggressor, the killer reasonably believed that they were in imminent danger, the use of force was reasonable. This duty also requires the individual claiming self-defense to retreat prior to using deadly force. In the wake of Kyle Rittenhouse behavior, 2 men are dead, and they have families. Joseph Rosenbaum, 36, Anthony Huber, 26. Their families are hurting. And then one was drastically injured, Gaj Groskas, drastically injured. And yet, we find the self-defense law was used for the alleged interpretation of justifiable homicide. Shameful. The law needs to be reviewed. Someone said, was he not even guilty of a traffic ticket? Could you frame the case in a young person who left their home and secured an AK-47? The representation is that I came to protect. Then why wasn't the question asked to the young man, did you not land in the midst of protests? Did you not head directly to where the police were? Or did you surround yourself where protesters under the First Amendment had a right, in this instance, to be angry and agitated, but nonviolent? They were unarmed. So if your reasoning was to go to protect, then go to the protectors. That was not the case. This was a false narrative, ill-conceived. And although 17 or 18 he had the wherewithal and should have been held accountable for not going to where he said he was going to go. And the prosecutor in the Ahmaud Arbery case had it right. You can't come to provoke and then declare self-defense. That is what happened in the Rittenhouse case. Tragedy of the shooting of Jacob Blake. Those there were agitated. Some might say rightly so. Some were there to do other things. But the real issue was, did they deserve to die? Was this gentleman anywhere near police? No. He came to provoke and then claimed self-defense. I believe there should be a federal review of self-defense laws across America. And I will share with you why. Because Anthony Huber is dead. Because Joseph Rosenbaum is dead. Because Gage is severely injured. But yet, this is supposed to be the picture of someone who only came to help. Didn't get to the body of police that were down the street, technically. Didn't make a beeline, as some of our parents would say, make a beeline for home. Didn't make a beeline to get right to where the police were and get instructions from the police. Was in the midst of those who rightfully could be protesting with some dispute as to what they might have been doing, but that was the charge of law enforcement. To my knowledge, that night, law enforcement did not kill anyone. And ultimately, the protesters left the area. Self-defense laws across America need to be reviewed because too many people are dying under this false premise that everybody can use self-defense. What about the Castle Doctrine? That is an expansion of self-defense, both statutory and at common law, in which removes the duty to retreat for self-defense on individuals inside their home. This principle has been codified and expanded by the majority of state legislatures in a variety of ways. However, the boyfriend of Breonna Taylor, who was defending her and the home, was arrested, an African American. These laws need to be reviewed. They're state laws, but they are unequally applied. Enough is enough. Stand your ground laws. Stand your ground laws are an extension of the Castle Doctrine to areas outside of an individual's home, such that there is no duty to retreat for self-defense. The name is derived from statutory language found in several states. This results in the imbalance, if you will, of justice. Racial disparities are much larger as white on black homicides have justifiable findings, 33 percentage points more often than black on white homicides. So as the father and son thought that they could kill Ahmaud Arbery, they were hoping for the odds that they would be found not guilty because they killed a black man and they claimed self-defense. Stand your ground laws appear to exacerbate those differences as cases overall are significantly more likely to be ruled justified in stand your ground states than non-stand your ground states. We'll talk about one of the most notorious cases. With respect to race, controlling for all other attributes, the odds a white on black homicide is found justified in 281% greater than the odds of a white on white homicide is found justified. So if you happen to be white and kill a black person, 281% of the time, you're innocent. You're innocent. By contrast, a black on white homicide has barely half the odds of being ruled justifiable relative to white on white homicides. Let me be very clear. I want all lives to be saved. I want black lives to be noticed and known and matter. I want to make sure that the justice system is fair. Justice should have no color. The scales of justice, Lady Justice. That is what the Judiciary Committee has been advocating and working for the decades that I've had the privilege of serving. Statistically, black-on-black homicides have the same odds of being ruled justifiable as white-on-white. White men are more likely to successfully invoke the use of stand-your-ground laws for their defense after shooting than black Americans or women, especially black women. Nationally, the likelihood of a homicide being ruled justified is 281% greater greater when the defendant is white and the victim is black. Need for federal intervention and review. In contrast, the likelihood of a homicide being ruled justified when the defendant is black and the victim is white is 49% lower compared to cases where both the defendant and victim are white. And 68%, according to the Coalition to Stop Gun Violence, of successful stand-your-ground law claims in Florida, the person was unarmed. So let me quickly move to these cases. As I do so, let me add to my discussion, and that is the citizen's arrest. The citizen's arrest law that was used by the defendants in the Ahmaud Arbery case, and let me offer my sympathy to those killed by Mr. Rittenhouse and to the family of Mr. Ahmaud Arbery. Let me give my sympathy to the families of Joseph Rosenbaum and Anthony Huber because their loved ones are dead. But in this case of, one has always said, a praying mother, a praying family, the citizen's arrest law cited in Arbery's case dates back to the Civil War. This case was used, as the prosecutor indicated, a Civil War era state law to justify the killing. Since 1863, Georgia has allowed its residents to arrest one another if they witnessed a crime and the police were not around. Similar laws have existed nearly every state. The citizen arrest laws in Georgia in 1863 were utilized on the pretense of getting freed slaves. They were free, but by their color, there were those who said, "You're not free, I'm arresting you. You're violating the law. You escaped." How horrible to have this kind of bounty. So the citizen arrest laws should be very clear. The defendants were wrong. The case resulted in a conviction because the case says that you have to witness the crime, and they did not. So let me quickly say that we've got the castle law, the stand your ground, self-defense, and citizen arrest. I believe all of these should be put into the mix of review, and there should be federal law that governs how these state laws are done. Oh, someone is going to argue the 10th Amendment and states' rights, but if you have these numbers of inequity in killing and justifiable homicides in race is a factor, it needs to stop. I know Trayvon Martin's mother and father. They have worked without ceasing. This is the saddest and most horrific and heinous results of stand your ground self-defense. This young man was just walking with Skittles and walking with an iced tea. I heard the description of a young man being confronted by a grown-up and fearing for his life, tumbled to the ground with the grown-up and was shot point blank. The grown-up was acquitted because of stand your ground, self-defense. The federal government needs to intervene. Ahmaud Arbery, with a praying mother. Georgia law requires the witnessing of a crime. I see a man running for his life. a man of dignity running for his life. But yet, it took 3 prosecutors to get to the point of acknowledging the human dignity, the humanity of this young man. We have yet to get justice for this mother's child, and that is Trayvon Martin, and many others who have fallen unnoticed under the arm of stand your ground, self-defense, citizen's arrest, and the castle law. I think we should be very clear. I am not looking to take away the rights of homeowners legitimately protecting themselves, or self-defense when there's no other option. But we've allowed gun violence to take hold of the psychic and the behavior of America. And as the Giffords Law Center said, a 32% increase in rates of firearm homicide and a 24% increase in rates of homicide overall, 45% increase in firearm homicides among adolescents. With the extreme amount of gun violence, we need to determine whether or not every state self-defense law should be defined specifically, and there should be a requirement of retreating where you can. We should determine that if there are states with citizens arrest, that the onus is on the individual seeing the crime to call official law enforcement. We hope those law enforcement are trained to not take actions into your own hands, to not allow your judgment to supersede those who are trained and wear the uniform. The castle law, stand your ground when you have other options than to shoot point blank and to kill people. And if you are a 17-year-old with an AR-15 and you can go into court and there's not one aspect of your behavior that is illegal, then there needs to be a federal review of the state law. There was nothing to attribute to this individual that they'd broken the law, coming across state lines, that they provoked the incident, and yet they were able to use, unfortunately, the stand your ground and self-defense law. Gun violence continues to be a disease in this country. As I said, if I could just for a moment more talk about the citizen's arrest. For example, the Georgia citizen's arrest law, which was at issue in the Arbery trial, was codified section 17460, grounds for arrest. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge, if the offense is a felony and the offender is escaping or attempting to escape. None of that occurred with Mr. Ahmaud Arbery. It wasn't in their knowledge. They didn't see it. The offense wasn't a felony. It might have been trespass if it even existed. The offender is not escaping or attempting to escape. He was on a Sunday or a jog, which you as a free person in the United States should be allowed to do. A private person may arrest him upon reasonable and probable grounds of suspicion. Codified from the Civil War in order for citizens to really and legally detain runaway slaves. And other southern states enacted similar laws for similar reasons during this period. Nothing but a figment or an action of Jim Crow laws. It is time for the federal government to step in. I question, with so many guns in America, whether it is safe to continue a relic like citizen's arrest. There are 18,000 police departments in the United States of America. With the right kind of training, there is no reason why any individual could not retreat to call law enforcement or to call law enforcement appropriately. So tonight I came to honor those whose lives were lost and there was no response, none whatsoever. And Trayvon Martin becomes singularly that symbol. Even Tamir Rice or Breonna Taylor, or maybe even Eric Garner. These cases must be addressed, and I look forward to addressing these for the nation and working to secure hearings and witnesses how wrong these laws are and how unequal they are and how scattered they are and undefined they are. As I close, and I thank the Speaker for her kindness and generosity of the time, that we must recognize the value of our constitutional principles and that little book, that the Bill of Rights, that guarantees us the freedom of access, due process, the right to vote, a constitutional presence in this nation. And these laws, under a criminal, unjust system, have to be changed. And America needs to know that the killing of individuals with no adjusting and accountability is unacceptable. I'm on the floor this evening to indicate that enough is enough, and we must proceed with the review of laws that can kill without accountability. In the names of those and the loved ones who suffer because they're gone, I commit myself to addressing with my colleagues the injustices that exist today. No more. No more. Grateful for the Ahmaud Arbery, but no more will we stand for this inequity. I yield back.
The gentle lady yields back. Pursuant to Section 11B of House Resolution 188, the House stands adjourned until 8 a.m. tomorrow for morning hour debates and 10 a.m. for legislative business.